I now propose to go through the measure, article by article, in terms of its operative parts, to examine the opportunities that now present themselves, the guarantees that are available, but also to look at some of those items which have been negatively amended by the authorities in relation to the original proposal. I'm going to skip the recitals, although clearly they are very important, and concentrate on the operative articles. We don't have the time to go through each article line by line, and I propose to simply take headline points from some of those articles that appear to me to be of the greatest practical application. The first article I propose to look at is Article 2. The scope of the article indicates that these guarantees will apply to all persons who have been made aware by competent authorities that they are suspected of having committed a criminal offence. The guarantee will continue from that first point, which is the definition employed in the European Court of Human Rights cases, until the ultimate conclusion of proceedings, which means, of course, until the disposition of any final appeal. However, there was a second part to Article 2 introduced after the debate commenced, which effectively excludes minor offences, which are dealt with on an administrative basis, unless and until they come before a court. And that, I think, is a significant dilution of the original proposal. And of course, the same thinking is evident in the current debate underway in relation to Measure C. Article 3 sets out the right to information about rights. All practicing lawyers will know that it is absolutely at the centre of any effective guarantee that the person in detention has information about their rights. There is simply no point in having a right if you don't know about it. And therefore, I think the single greatest breakthrough in this measure is the fact that an official document will be provided to a person in detention in a language which they understand, or will be explained to them in a language which they understand, confirming a number of important safeguards that they have. Those safeguards are set out in Article 3, 1, A to E, and it is worth looking at each of them. 1A, the right of access to a lawyer. 1B, any entitlement to free legal advice and the conditions for obtaining such advice. Article C, the right to be informed of the accusation in accordance with Article 6. D, the right to interpretation and translation. E, the right to remain silent. Looking at each of these measures, we can see the importance for the person in detention. Very many persons are entirely unaware of their right to have a lawyer, and we would say, in the context of the recent decided cases of Saldus, Brusco and Civilage, and the thinking of the UK Supreme Court in Cadder and Her Majesty's Advocate, to have that lawyer with them throughout questioning. This is not the situation that prevails in my jurisdiction, and is one that is certainly likely to be challenged in the immediate term. The entitlement to legal aid is also vitally important because, in my experience at least, the preponderance of persons detained are of limited means and of limited opportunities to present and protect their rights, and the entitlement to have those rights protected by a lawyer paid for by public funds is a vital protection. The right to be informed of the accusation is self-evident because persons must know why they've been detained, and without that information they're not in a position to even start the preparation of their defence. It is of note that in the original Article 3 proposal there was reference to being provided where appropriate with the case file. This has been removed, and while there is, as we shall see, reference to the case file further on in the document, its primacy has certainly been diluted in the manner in which the measure was changed during the debates. The right to interpretation and translation is a vitally important right, and was in fact reflected in the first part of the Stockholm programme to be implemented, Measure A. Of course, in individual member states, this is going to have a colossal financial implication because of the movement of persons throughout the European Union and the movement into the European Union of persons from many other jurisdictions. The availability of the translators with adequate experience and independence is going to be a major challenge in most countries. The right to remain silent is again vital that it is communicated in an official form and at the outset of detention. This should and hopefully will be a significant counterbalance to the inducements frequently provided by policemen investigating and interrogating suspects, to the effect that it would be better for them to make a clean breast of it, it would be better for them to tell the whole story, when frequently, of course, it is very much contrary to their interests to speak at all until they've had the benefit of a private, professional consultation with a defence lawyer, independently protecting their interests. The second part of Article 3 makes a very important point that the language in the Letter of Rights to be provided to implement Article 3.1 must be simple and accessible. And it also makes the vital point that it is to have special regard to vulnerable persons and people of limited intellectual capacity.